I've been asked to talk a little bit about the background and context of Barratry, and I'll be very brief. Sir William Blackstone, who, as you can see, started practicing about the time Guy Harrison and I did, said in 1765, common Barratry is the offense of exciting and stirring up suits and quarrels between His Majesty's subjects. And if you ask lawyers, when we go to these seminars and speak on Barratry, what is Barratry? What you hear is, well, that's case running. It's case running. And that's a small piece of it. And if you look at the history of Barratry, which most states do not have as a crime, but if you look at the history of Barratry, and you look at our rule, disciplinary rule 8.04A9, which says thou shalt not engage in Barratry as defined by the laws of the state, if you look at that and start asking yourself what Barratry is, you'll find that most lawyers don't know the details of it, and the system doesn't deal with most of the details of it, and that's probably good. But if you look at the common law in Texas, you still see those dictionary definitions, the vexatious excitement to litigation, especially soliciting clients. And in one sense, that is sort of the essence historically of Barratry. Our remedies, I see it in all three arenas. I see it in the disciplinary arena, occasionally, criminal arena, and more recently, since 2011, which Bill Edwards will talk about, the statutory amendments creating the civil Barratry remedies, I see a lot of those cases. I'm aware of probably 100 claims now, just anecdotally, around Texas. And I think that's probably doing more to raise the profile of Barratry than anything else. It'll be interesting to see how that affects the criminal and disciplinary arenas as time passes. Our basic rule, 804A9, don't engage in conduct that constitutes Barratry as defined by the law. So if you ask a lawyer, where's the definition of Barratry? No one can find it because there's not one in the law as such. We have that general common law dictionary notion, and then we have functional definitions and statutes. The other two disciplinary rules I'm seeing, and this is really an outgrowth, I think, of the civil Barratry statute, with more lawyers, particularly plaintiffs' lawyers, thinking about civil Barratry claims. Rule 706. Rule 706 prohibits accepting or continuing employment if you got the case, the employment, through Barratry. I'm now seeing that used, I'm aware of two cases in which that's been used as a defense in a civil suit. I've seen motions to disqualify filed saying, Mr. Plaintiff's lawyer, you got this case through Barratry, you shouldn't be in this case. The rules prohibit it. That's public policy, so you should be thrown out of the case. And then you have these sort of collateral Barratry fights. We've never had that in the past, and I attribute that in large part to the 2011 amendments creating the civil Barratry remedy. It's made more people conscious of it and thinking about it. So I'm seeing defendants in civil suits trying to raise all sorts of Barratry defenses, including public policy and including the disqualifications. And then we have 804A2 and B, which simply define it as a serious crime. But the core statute, the functional statute, is the Penal Code provision 3812. And that began in 1876, and as recently as 1990, you still would read Bar Review and Bar Journal articles saying, no one knows of any criminal Barratry prosecution. Just doesn't happen. And, you know, that's after a lot of years. But that's changing, and we'll hear from the prosecutors about how hard it is to prove the classic Barratry, the case runner. How do you ever get the evidence? Lawyer pays case runner, cash, goes solicit that accident victim. How do you ever find out about that? Unless the lawyer is stupid enough, as a few of them have been, to not pay the case runner, and the case runner is stupid enough to go turn them in and say, I committed a crime, and I'd like you to get this lawyer who was my co-conspirator, co-actor in the crime. But we'll hear talking about that. But look what's changing. Now here's State of Texas versus Ronald Eugene Reynolds, a state representative. That case is set for trial. I believe it's set for trial next month. High-profile indictment. There's a Commission for Lawyer Discipline case, Barratry case against him as well. And again, these are things we didn't see much in the past, so maybe things are beginning to change a little bit, but I think it's still slowly in the disciplinary and criminal arenas. The basic statutes to look at, 3812, as I mentioned, and then 38.01, which you need to look at for the definition of solicit under the criminal statute. The structure is this, 3812, read it sometime. Very few lawyers ever read it, and it's a very complicated statute. Basically, the offenses are in subsections A and B and D. And then C has an exception that we'll come to because the prohibitions in A are so broad that everyone would be convicted of Barratry if we didn't have that exception. Subsection E has a special definition, and then we have penalties, different levels of penalties in F through H. And subsection I is somewhat superfluous now. It says a felony Barratry conviction is a serious crime, but we already have that covered in 804A2 and B and the Rule of Disciplinary Procedure definition. But look at A. Okay, here's Barratry, and most lawyers don't know this. The first offense is instituting a suit or claim without authorization. Instituting a claim without authorization. And we have a Rule of Civil Procedure 12, which allows a lawyer to file, a party to file a motion to show authority. Did the lawyer for the other side have authority to even represent the client? And we see that in like small corporation disputes where I'm filing the case, no, I'm filing the case because you have a stalemate or dispute among the corporate controllers. I've seen one case, and James may know of others, that hit the disciplinary arena dealing with that issue. Goes back to the 1500s of that prohibition in the ancestors of our Barratry law. Soliciting, the second one is soliciting employment by phone or in person. Well, that's everything, right? And that's why we need an exception, because that prohibition is so broadly worded that we'll see the exception in 3812C says, except if allowed by the disciplinary rules or court rules. And then we see what we generally, more classically think of as the essence, the key Barratry violations, and that's paying or giving anything of value or accepting anything of value. And that's worded several different ways, but that's the essence of it, to get professional employment. And A has three provisions on that. And then if you accept employment, that's also a crime and also ties into the other disciplinary rule violations I talked about. B is basically financing those kinds of violations under A, or knowingly accepting employment from that. And then C has the exceptions for those broad prohibitions in subsections A and B. This says, except, it's not an offense, if the disciplinary rules allow the conduct, approved advertising, approved solicitations, that kind of thing, or court rules authorize it. Now, D is the one that after 2011 really scared the civil lawyers, the plaintiffs' lawyers, because D is a very, very broad prohibition. It remains very broad. I've yet to see it used in the criminal arena this way, thankfully. But if you read it, as it applies to lawyers, it has several prohibitions that apply to lawyers as well as chiropractors and others who permit to be provided a written communication or a solicitation, including phone or in person. You allow somebody to make a solicitation. You make a solicitation, or you allow somebody else to. And number one, it violates the 30-day deadlines. Most people are aware of those, and that's pretty simple. In 30 days, you can't solicit after an accident or a disaster, 30 days after a divorce is filed. Or it concerns a specific matter in which the lawyer knows or should know that an attorney represents the person. I see that come up a lot in the mass torts because I get complaints about lawyers stealing other clients' cases. The tort du jour, vaginal mesh, or one of the other big ones that have thousands and thousands of cases filed. Some advertising lawyer will come in and make contacts and swoop in. And I've not seen one of those hit the criminal side. But I see a lot of those complaints among plaintiffs' lawyers. And then providing to an injured person or relative someone who's indicated they don't want to receive a solicitation. That's defined in that other provision, 3812E. But then this is the one, these two prohibitions under 3812D are the ones that were frightening under the 2011 version of the statute because the 2011 civil Barratry statute allowed a cause of action for these violations. The 2013 does not. But it's that solicitation, provided or allowed to be provided, that involves coercion, duress, intimidation, undue influence. That's one category. And then lastly, the real big one, that contains a false, fraudulent, misleading, deceptive, or unfair statement. So, solicitation, deceptive. That was, and there were a slew of private lawsuits filed in the 2011 version of the civil Barratry statute. What's deceptive? You can get your ad approved by Advertising Review, and you still can have to litigate on the merits whether it's deceptive. And consider the definition of deceptive under DTPA. Look at the Business and Commerce Code, Section 1746B24. That's the one that says it's deceptive, one of those laundry list items, if you didn't tell a consumer some information that led the consumer to enter the transaction, and the consumer wouldn't have entered the transaction if the consumer had that information. In other words, you concealed information. Didn't tell them you'd never tried a jury case. And we saw some very interesting suits filed over that. But that's still in the criminal statute. I have yet to see it used, make my anecdotal radar screen, but it's there. It's a very broad statute. A lot of it's been added piecemeal. A lot of the Barratry statutes nationally and globally have been abolished. It's sort of considered to be an anachronistic crime, but it is alive and well in Texas. And we get a lot of anecdotal complaints, and I know James does as well on GOC, about people who call and say, gosh darn, down here in this part of the valley, there's this guy running cases. And we just know he's doing it. And why didn't somebody do something about it? And I'll turn it over to those who do something about that, or try to, and they can talk about how difficult it is.
Well, thank you for that lead-in. Trying to do something is exactly where we are, all right? Because this is one of the hardest criminal statutes to prosecute. I'm the major fraud division chief of Harris County, and believe me, we see all kinds of fraud at all level against everyone and every kind of individual. When it comes to lawyers, we have an abundance of complaints, as I'm certain my counterparts do as well. I think the problem always is when you're dealing with the crank calls and when you're dealing with objective evidence. When you're in a criminal arena, we're dealing with a lot of very important and significant aspects of someone's livelihood and career. We don't take this very lightly. We want the profession to be held accountable, but we also know that there is a lot of room for misinterpretation and room for the evidence. What is the evidence? We're dealing, as Chuck has just gone through, and we're going to go through it a little bit too, a very complex statute. One of the hardest ones, and I bet many of you have never even looked at it. I know that in my office, when someone hears about a Barratry case in another section of the office, they holler, they freak out, they contact, they call the major fraud people. You know, we don't want to have anything to do with this. And this is our intake section, all right? So, so it is not something that people like to even grapple with as prosecutors. We have very sophisticated targets. Those targets usually have a lot of money, and they hire very sophisticated lawyers to defend them. So we want to make certain that when we come after anyone, we have got the evidence, and we're not just talking about speculation. One of our biggest situations is the reluctant witness in these cases. How do the Barratry cases get reported to a district attorney's office? I would imagine that in most offices in this state, they come through other attorneys. The clients don't care. Quite frankly, unless there is a bad result, all right, and then we have all kinds of other issues in that kind of situation. But we don't hear from the clients. We don't hear from the runners. We hear from other people in the practice, and it's something like Chuck just mentioned, as well as James, that we just know it's happening. We know it's happening over there because look at the business that they're getting. And we're not getting the same business. So it begins and it starts off at a very difficult situation of, number one, where's the evidence, but also what's the motivation? So in looking at this, you know, the motivation should be we are trying to protect the public from unscrupulous individuals who are coming in and using undue influence, using coercion, using misleading statements and representations to the potential client as to what the results are going to be. You can't predict the results. None of us can predict these results, and especially in places like Harris County, where heavens, who knows who's going to come in on the jury pool? I mean, no one knows. So we need to get away from that aspect as a profession. We need to be educated as to what Barratry is, and we need to help our colleagues be educated about this, so that there's plenty in the pot. There is plenty available for people to share when we're looking at legal fees. But more importantly, there's a level of integrity, and honesty and justice for people and citizens in this state to be able to choose the lawyer in a situation where they can be reflective and go forward on their cases. As Jessica mentioned, I mean, especially in the criminal arena, these are life-changing events for individuals when someone comes forward with an information or an indictment against them. So it's really important for people to be objective in taking on that case, as well as from my position as a prosecutor in reviewing the evidence. When you look at Barratry, we've got a variety of punishments here. Under subsections A and B of the primary 3812, we'll go into that. Chuck just mentioned it. This is the third-degree felony. We have a 3-year limitations on whether or not this is brought and prosecuted. So we're moving, and many times things are not brought until the very nth hour. And like magicians, we're supposed to come up, with our indictment very quickly, and we're not going to do it in Harris County. We are going to be, as I've said, we're going to look at the evidence very carefully on these cases and whether or not we can go forward on it. The subsection D, which is dealing with primarily that 31-day rule, the letters of solicitations, or after 31 days after that personal injury event or disastrous event, that's the Class A, and it carries a 2-year limitation. And then there's an enhancement also provided in the statute if you do in fact have a prior conviction under subsection D, it can become a third-degree felony on your second time. So you want to read the statute. You want to become very informed about what are the do's and don'ts in moving out into the community and looking for your practice. Under section 3812A, this is what we're looking at. Look at, as a prosecutor, we like something simple, to be able to come forward with our proof. But when you look at this, we have an intent, a mens rea, right from the beginning, with intent to obtain an economic benefit. So right away, we've got that challenge. We've got to then, I've highlighted basically the 4, knowingly institutes a suit or claim that a person has not been authorized to pursue, solicits employment, either in person or by telephone, for that person or another, pays or gives or offers to pay or give a person money or anything of value to solicit employment, and then finally the accepts or agrees to accept money to solicit employment. Now that subsection D right there, that is the one that frequently is the easiest one that we can come forward with and actually prosecute. That normally is not the lawyer, all right? That is our runner or the person who has received the money, because normally in those situations we've got a client who's willing to talk to the state. Now, just kind of, think about the dynamics in these situations. This frequently comes forward. We hear about the civil barratry for the personal injury runners, but generally we don't see those cases in Harris County come to our office where we have competent evidence to proceed. Normally it's the criminal arena that where we have people who are willing to come forward and talk to us about allegations concerning this solicitation or payment of solicitation. But in all of these, we start with this threshold, with intent to obtain an economic benefit. That's what the person who is target of this offense, we must satisfy that mens rea. Now, how do you do that? We've got to know what this agreement is for payment. We've got to have some proof. It's just not a speculative, why else are they doing it? That's not how criminal law operates when we're dealing with, beyond a reasonable doubt. So we are looking for some evidence of that fee agreement. Is it a contract? I mean, do we have any paper, any document that will support the relationship that is the economic benefit? That's the kind of thing that we are looking at. Without that, what do we have? There is not a crime for someone to come to me and ask me, well, I need a lawyer. Can you help me? Who would you recommend? That is not a crime unless I am what? Getting some money, getting some payback, getting something of value back. That's what we are looking at the threshold. And recently, in a case that is currently under investigation in Harris County, there was an individual who was doing something interesting in the courtroom that was brought to the judge's attention. And the judge, it's Barratry, get on this, calling me up, screaming and yelling. And so, we come in, we go interview, we look at this and we go, show me what the evidence is right now, that you believe exists on this economic benefit. And the judge looked at this, and I never knew that part was in there. I never knew we had a mens rea. Now, this is kind of what we're going back to. Very few of us know about this statute and about the difficulty that it presents. I'm not saying that necessarily we need to change it, but it does present interesting challenges from a prosecution standpoint. Another challenging piece is, what is the relationship between the licensed lawyer and this person who is soliciting, or the lawyer is asking to solicit? We have to know about that relationship. And how does that happen? Maybe there are some observations. Maybe there is, some conduct that we are seeing either in a courtroom, outside a courtroom. Maybe we've got someone coming forward who is the family member, of the person being represented, that adds and gives us some information about the relationship. But generally, that is a missing component as well, without somebody cooperating. So this is one of these kinds of things that when the complaint is coming from the bar, from members of the bar, and not from the parties involved because of their own personal actions of revenge or motivation, when the runner decides to come forward with the list and with the whole situation, we are thrilled. How exciting as a criminal prosecutor can we get when someone brings us the evidence on the silver plate? It's wonderful. And that's how you can make some of these cases when we are dealing with the larger group activity. Which basically is in 3812. the knowingly financing, investing funds, et cetera. When we're dealing with the conspiracy of the law firm and hiring the runners who are interacting with the police, or who are interacting with the ambulance chasers, or with the tow truck folks going to the scenes, this is where we need someone who will be cooperating with us. And many times, that's where, when we have a piece of it, we can run a sting operation to gather that information of corroboration, to record the statements, to record these relationships, and find more evidence, of the actual economic benefit and economic trade that is going on. So these are some of our challenges. How am I doing on time here? Okay, so what I'm just saying to you as we go forward, there's so much to talk about on these kinds of things, but most importantly, we represent integrity, we represent the law, we represent justice, and we need to help police our profession. We need to help the police, help law enforcement police our profession in order to keep it honest and trustworthy. Thank you. Yes, sir.
How many Barratry prosecutions have been in Harris County where you've actually indicted or prosecuted somebody?
Well,
That's not a fair question.
it's not a fair question, but it is it's less than 10, less than 10. Mm-hmm.
Have you got any convictions?
We have on the runners. Mm-hmm. Yes.
So what, as an attorney, should we do when that happens? I mean, I had a situation just last week where I had a client, a signed-up client, said she was approached at her home by a runner who told her, she needs to switch lawyers. He's contacting her insurance company. They've authorized him to offer $150,000. And this is one who didn't even have insurance. It's irritating. I'm done for the case because there's no case. There's no insurance on either side. But this guy came to and said that he's been authorized to pay $150,000, and he gave the number of the attorney's law firm. Because she called me immediately with some very choice words as to why he can give me money and I can't. So what do you do with that?
Well, I mean, if you believe that this person has credibility and is trustworthy, there's some corroboration, then I mean, bring that to your local district attorney's office. Bring that to the state bar, who can also investigate these cases and frequently does then hand us over the investigation. So or hands over to the district attorney the investigation findings.
Now, Mr. Harry, you were talking about tying it into the DTPA. How do you make that nexus when, to get to DTPA, you have to be a consumer, and Barratry is an unsolicited?
Right.
So how do you get there?
My only point is that one of the prohibitions in the criminal statute deals with certain solicitations that are deceptive, which is the broadest category of prohibition. And where do we know the most about deceptive? DTPA. It's a analogous area of the law that teaches us about what is deceptive. It's not independently actionable. Now, Bill Edwards will talk about the 2011 amendments to the civil Barratry statute, and has had pretty good luck, and really one of the pioneers of the civil Barratry remedies in Texas. Pretty good luck proving some of these, and I think he can do some things that it's harder for the disciplinary authorities and even the criminal authorities to do, and can probably speak to that as well.
And you need to be ears, because you need to hear this. I really want to thank Terry Tottenham for all that information he gave about the old folks. I'm going to pass it on to my 59-year-old lawyer daughter, because she really needs it more than I do. Been a busy week. By the time I left my office yesterday at 7:15, I had 24 hours on the book, real hours, because I started about 4:30 Monday morning and got home at 8 o'clock Monday night. Started early Tuesday morning, left the office at 7:15. You can count them up if you want. I also want to tell you that Mr. Majors, we refer to him when he's not listed as Sergeant Majors. He takes care of our advertising. And does he ever do a job? You know, I got busted because my ad only had the name of my firm and the city where we were located on the screen for 3 seconds instead of 5 seconds. As though I want to hide where I am or who I am. In any event, people always ask me, why the heck are you still practicing law? Number one, I love it. Number two, I've been lucky enough to have whatever it takes to be physically able to do it, because I run my law firm, which is a fairly sizable law firm, and carry a docket, which I personally take care of it or oversee some of the younger lawyers, about 150, 160 cases. And so I stay busy at it. But in order to do that, it takes a lot of things. First of all, I did a lot of athletics in my younger life, and I knew you had to work out to do that, so about 25 or so years ago, I decided if I was going to keep up doing this fool stuff that I like to have so much fun doing, I better start physically training, and I did. So I train for what I do. Secondly, I don't know what the heck else I would do. Thirdly, I took a page out of my old mother's book, bless her heart, she's long gone. Every 10 years, she would drop back, she'd get rid of all her friends, drop back 10 years to pick up another group of friends who were 10 years younger. Okay? Did two things. It kept her young at heart, and there were a heck of a lot less funerals to go to. But more important than anything else, I thought about retiring about 20 years ago, and I went home for about 3 days, and my wife told me, she said, Edwards, I married you for better or for worse, richer or poorer, but I damn sure didn't marry you to come home on the couch and sit and watch TV all day. So here I am. Let's talk about Barratry for a minute. I got on this kick 20 years ago or so. I just didn't like it. I probably should have been a prosecutor. But I didn't like it. It's what we talk about, Barratry, case running, ambulance chasing. I finally have come up with a term that the public will understand. Cheaters. That's the word. They are cheaters. They violate the law. They want an uneven play field. They are cheaters. And I also got more involved in this as the cheating, if you will, in the area of the law which I practice, which is personal injury law, became worse and worse and worse. I am convinced, and I can give you some examples in a minute, that this particular aspect of misconduct affects not only our legal profession, it attacks the very heart of our entire civilization here in this country. It underscores undercuts the legal system. It undercuts the prosecutorial system. It undercuts the legislative system and the judicial system as a whole. You want an example? I'll tell you, there's a book out there called The Case Runner, written by a former assistant DA from Cameron County. You ought to read it. I will tell you this. I read it. I could recognize, he claims it's not real, okay? I could recognize the names used in the book. They're kind of hidden. But if you know the players, you know the names. And since the conviction and the incarceration of the local lawyer here, Mark Rosenthal, who has just finished getting sentenced to 20 years in the pen, you'll find that everything in that book is true. And he was taken down by Judge Lemus, former Judge Lemus, who's also in the federal pen. Okay? And Jim Solis, who's a former representative from Cameron County, who's also in the pen, along with about 10 or 12 other lawyers. And the main center of that thing was a case of a helicopter crash that was run and generated a fee of about $6 million, which incidentally, Rosenthal has been ordered to pay back as restitution. which was divided up among a lot of people, including the judge and a former representative. Bad stuff. There's a guy down in the valley now. Can't get my hands on him. Name is Willie Garcia. Incidentally, I use these names and I invite them to sue me for slander, libel, whatever it is, if they got the guts enough to do it. And I will say this, the work I do in this area reminds me of the famous military guy, I can't remember his name, he wasn't that famous, but said if you're not taking incoming fire, you ain't shooting at the right people. Well, I can tell you, I'm shooting at the right people. I can guarantee you that. But Willie, he was doing okay. A guy came to me, got a bunch of money out of the BP explosion, the refinery in Houston. Willie got him to give him $1.2 million to help him invest in Willie's business, which was case running. And the guy came to me, and we were trying to get the money back from Willie because he didn't pay it. He signed a note. And as security, gave him an interest in about 250 cases. I've got a stack of papers this big with the list of the name of the case, the style, et cetera, where it was and what happened, as security for the loan. From cases all over the world. Willie came to my office to try to settle those cases. And I'm not telling stories out of school because I got this on tape and pictures. He explained to me how it worked. He had an office in Mexico City with approximately 26 or 27 lawyers, including the sister-in-law of the then president, Vicente Fox, and tentacles into the consulate part of the Mexican government. And using the consuls around the world was picking up cases from all over the world. At the time, he had just scooped up a bunch of cases in Siberia from plane crash. I think about 40 cases. God knows how much money we're talking about in those 250 cases that had been hustled from Siberia to the Spain Air crash in Spain, one in Indonesia, one in Colombia. I had one runner in my office who explained to me how in one day, using a jet plane from the lawyer, he signed up big cases in Indiana, got a call, said, oh, you got that one? We got one in Buffalo, New York. Well, you got that signed up? We got one in Los Angeles. So in one day, he left Corpus, went to Indiana, Buffalo, New York, down into California, and came home with 3 big cases with fees probably in the $10 million range total. He's going to get a cut of what, a third? Pretty good day's work, right? Pretty good. Well, the difficulty is in prosecuting these things. Lawyers don't want to turn anybody in. I kind of solved that problem. I got the word out among the people who got a gripe. Look, you don't want to turn them in? Get me an affidavit from your client. I'll turn them in. They started giving me notices of hearing. I said, I don't know anything about that. All I am is a conduit with the affidavit. You go take care of it. But that does take care of that part of it. Do the DAs want to do it? Harris County is a very unusual place when it comes to prosecuting these things. Most places, the DA will turn their back. The people with the bucks as a result of this kind of activity are large contributors to campaigns. A fellow in Corpus by the name of Mauricio Celis, he had a record at the time they tried him for impersonating a lawyer of about 2 years before, $360,000 in campaign contributions to various local candidates there in Nueces County. Man, that's a lot of money for one guy to kick out in that county in that short a time. He ended up getting convicted for 14 felony counts. He was supposed to spend 6 months in jail as a condition of probation. We had a little Mickey Mouse going on among who knows, the ex-judge, and next thing you know, he ain't got any time in jail. It went away. That's been approved. That has been affirmed. They're standing out there behind each of those convictions, an indictment for money laundering. Okay, there's 14 present live indictments for money laundering, the key to linchpin of which was the illegal money that came from impersonating a lawyer. I ain't seen any prosecution. I've heard there's been discussions between the DA in Corpus and the Attorney General's office. I ain't seen any action yet. It'd be real interesting to see whose money was being laundered, I'll guarantee you. Well, at any rate, those are the things where we've had problems. I became convinced that if we could get a civil action that was related to Barratry, we could do something about it. And I think we have. In 2011, before the legislature met, the only thing of a civil nature statute that would give you any cause at all was section 82.065 of the government code. And it said that a contract, if you had a contract, contingent fee contract for legal services, and it had been the result of illegal Barratry activity, that the client could void that contract and get back the attorney's fees. And that was it. The case law on that said if that case was not brought against the lawyer before the underlying case was settled and the money distributed, it was all over with. The client would have waived the right. That was not much of an incentive to anybody. So I and others went to the legislature, and we got the government code 82.0651 enacted. That one did several things. It, among the important ones was it gave a cause of action to a person who had been illegally solicited and did not sign a contract. That was important at the time because there was a hole left in it which was taken care of in the legislature in 2013, which plugged that. You didn't have, either you signed a contract or you didn't. But if you were the victim of Barratry, had not signed a contract, you were entitled to recover, not just entitled, shall recover, the act says, a $10,000 penalty from each person involved in that activity, plus attorney's fees, plus any damages you suffered as a result of it. The hole was there because the first part of that had to do with people who signed a contract. And if a person signed a contract and it got over with, or even if it didn't, there was no penalty, there was no attorney's fees, there was no nothing. That's been corrected effective September 1 of 2013. So now we have a system where there is, and this is an answer to your question, we now have a cause of action against people who solicit whether you've signed a contract or not. Right now there's a dispute on whether the person who's entitled to collect has to be a client, because the first two subsections of 82.0651 refer to client, the last two refer to any person. And my position is any person means what it says. There's one case in Corpus where the judge has ruled any person means any person. There's one case that I know of in San Antonio where the judge says any person means client only. When you look against the purpose of the act as stated in the act to knock down on Barratry across the state, that being the purpose, and the section that says it will be liberally construed to achieve the purpose of the act, I think the any person is correct. Now, we refer to those calling cards from the runners as bonus cards. But what we've heard about the prosecutions are equally true in the civil area. Somebody called me last week on a situation like this gentleman referred to earlier. I told him. He was mad because he got called. Here's what I'll do. I can help you if you do this. Call him back. Tell him you've had a reconsideration. You want his help. Get him in. If he's going to come in, we can probably set up a sting at that point, either with the local cops, with the bar, or with the Attorney General, any one of them. If we can get hard evidence, then you can go forward. Don't try to do it if all it is he said, she said. Okay? You getting nervous down there?
I'm ready to go.
Any rate, I believe we're getting there. We're moving ahead. We're cutting down on this stuff. I had occasion to be with a family at Vamsey over in San Antonio on a very badly burned victim about 10 days ago that a lawyer had called me and asked me to go talk to him. Those people had not, this was some 7 days post-accident, no one had touched those people. I will guarantee you that a year ago, they would have been hit by 2 or 3 or more case runners in Vamsey where people hawk the floor, stay in the waiting rooms, et cetera. I'll guarantee you that didn't happen this time. What we're seeing is that in the Anglo population, the runners are getting scared. Where we see the most running happen today in our part of the country is in the Hispanic population, particularly the less educated group. But there are people advertising to inform the public about this Barratry in different parts of the state. It's going to work. I would like to suggest that the bar ought to put together a pre-approved, you don't have to send it in with $75 ad on Barratry that can be gotten by lawyers for the cost of the tape or the disc that they can then plug their name into and run, and all they have to pay for is not the production, not the approval, but just get it in there where you can explain to the public what it is. And again, it ain't Barratry, it ain't case running, it ain't ambulance chasing, it's cheating. That's a word that is understood by everybody, and nobody likes a cheat. Well, thanks for your attention. If you have any questions, go ahead.